I think we're ready now to resume. Mr. Edelman.
Well, I don't know if there are any further questions arising from the exchanges we had immediately before lunch. But if not, can I just summarise where those exchanges might have got us, and hopefully summarise my submissions on this. So can I just close a programme that might cause some noise in my computer? The first, if one looks at the alternatives for which the insurers contend is that this clause and the clauses like it were intended to apply to the disease risk only where the disease within the relevant policy area was alone the proximate cause of the interruption or interference. And one reaches that conclusion, they say, either as a matter of the true construction of the clauses or the application of the but-for test. The alternative is that there is cover with the condition that the disease is present in the relevant policy area, and that is all required. All that is required. And there are two routes to that. The first is the court's route, intended operation through the true construction of the policies, that a case of the disease in the relevant policy area is simply a qualifying condition. The second is the alternative causation case. Disease in the relevant policy area needs to be a proximate cause of the interruption or interference, and the but-for test is inapplicable, either because it simply doesn't apply to interlinked concurrent causes, and a disease outbreak would necessarily be that, or because, given the nature of the risk insured, it cannot have been intended that the but-for test should apply. But seeing as the net effect of B is A, B being by concurrent cause A, the construction, that indicates that the construction answer that the court adopted is the correct understanding of the intended operation of the policy. One can follow the long route round through concurrent causes, or say that that's not actually, it's not actually a happenstance of what has happened in this case. It is inherent in the disease risk. And if that's really what the parties were contemplating, then rather than going through the legal loopholes of concurrent cause and the authorities and so on, one says, well, actually, if that's where one ends up, and that's where the law would end up, isn't it right then to say, well, that must be what the parties intended, if that's the conclusion you reach, obviously. If you reach in conclusion one, then I lose. And that's what, yes.
Well, of course, it's always neater if you can get there by making the policy mean what you want it to, but the problem with the construction route is that you have to grapple with what the policy says rather than rewrite it.
But if that is the reality of what is going on because of the disease risk, and it's usually when one does that, one's doing it for a particular situation. One's massaging it for a particular situation. But the construction that I'm advancing is because this is inherent in the nature of the risk. It's going to be the case whenever you get anything that is an outbreak, and as I submitted before lunch, it's only an outbreak that in real terms is going to be causing an interference or an interruption. So they're necessarily contemplating something so serious that despite the fact that you're 25 miles away from it, it interferes with or interrupts your business. So that's the submission I made. And so it's inherent in the nature of the risk. And that's why when I introduced it, I was talking about the nature of the risk, how they could have specified what was required within the policy area in order to make it clear, if they wanted to, that they were focusing on local only, and they're not. So then you ask, well, what really is going on? Why is it only something that's symptomatic? Why is it sufficient? It's, in this case, asymptomatic. Why is it sufficient just that someone in the area has caught the disease? Why doesn't it have to be something more like diagnosis and notification? And then it all starts to fit together. And you see, well, you know, it then makes sense that all they're talking about is a qualifying condition. And this is the way they've expressed it, but that's actually what they mean. Because if they'd have meant something different, they would have, the clause would have looked very different. And it would have been requiring something very different to have happened in the policy area. If you were with me either on construction or on concurrent causation, then the question is, do the words events, we're on page 852, I hope my lords have still got that in bundle C. Question, do the words events or incident change that conclusion? The court didn't really grapple with our alternative construction case. They just simply seem to treat this clause as being focused on the locality and therefore we fail. And even if they were right about that, the local only, they should have still gone, the local focus, they should have gone on to consider our concurrent cause case. So let's assume for the moment that you're looking at either of my approaches, either qualifying condition or concurrent causation route. And then you're asking yourself, is there anything else in the surrounding bits that prevents that conclusion? And the two things the court relied on were firstly the word events in 3.2.4. And I made the submission, I think, before lunch, before we digressed, that there were the word events. Firstly, it's just descriptive. It's not definitive. It's just a catch-all word that's been used to refer to everything that follows. And in any event, it's being applied to the concept of notifiable disease. But even if it is referring to a particular case, for the reasons we debated, it can't be requiring that particular case to be the sole proximate cause. It must be at least encompassing the prospect of that being a proximate cause, and we say necessarily contemplating, because if you've got one case of a notifiable disease and it's only symptomatic and it's something's interrupting the business, it's bound to be more. So that word of itself doesn't suggest that the occurrence, if it has to be even if it has to be something specific, is then the sole cause. And the same and that is consistent with the fact that Mr. Crane accepts quite rightly that this must respond to multiple cases of the disease. So if occurrence is a single case, it must be treating concurrent causes as permissible, and the word events is not preventing that. And the same applies to the word incident. Let's look at how that appears in H. The insurer shall only be liable for loss arising at those premises which are directly subject to the incident. We would submit that that is not being used in any the word incident is not being used in any definitional way in relation to C, because on the hypothesis that as Mr. Crane accepts, this must encompass necessarily a local outbreak. Even on his case, one wouldn't describe a local outbreak naturally as an incident. It's an outbreak. But even if one did, then one is just simply supplanting the word incident, supplanting for the word incident the word outbreak. One understands the word incident as meaning outbreak. Because as Mr. Crane accepts, this can't be addressing the one particular case. Can't be doing that exclusively. It must be contemplating an outbreak. And if it's contemplating an outbreak, there's no reason again why that word should be contemplating sole proximate causation as opposed to concurrent cause as well. And just finally, in relation to H, just the purpose of that. The purpose of that clause, those premises directly subject to the incident, would mean that if, for example, an insured had two sets of premises and the business overall was interrupted or interfered with at both premises by virtue of a disease outbreak within 25 miles of only one of them, only the interruption or interference at the qualifying premises could count. That's all I wanted to say about QBE2. But the reasons we submit that even if we said the court was wrong in its construction, it should have adopted the same construction it adopted. But even if it was right that this does require causation of the disease in the policy area, the words don't go far enough to require it to be the sole cause, and concurrent cause is enough. And QBE3, just so you've got the policies at 955, it's got one less reference to incident, but it's essentially the same clause. And so, but the other difference is it's got 1 mile. It's not 25 miles, but 1 mile. We say 1 mile radius makes no difference. It just means that the disease outbreak must have a case somewhat nearer to the insured premises for cover to be triggered. But the principle is the same as the court below recognised when dealing with other 1 mile Hiscox 4 policy. Yes, my Lord Northampton.
Just on the 1 mile point, what do you say about paragraph 418 of the judgment in terms of?
Well, that flows from the conclusion that the court drew. What they concluded was that this was only concerned with the local incident having to, as they construed it, the only cause. Is my reading of that, and because one has to read the judgment as a whole, and they've already said that and they said it on a number of occasions through the judgment, that each case was made its equal contribution to the government's actions. So this is only consistent with their understanding that this could be the only cause, and all they're saying is it simply cannot be said that any such local incident caused the imposition of the government restrictions, which is simply reflecting my concession that if you have all these pins on the board, if you take one pin out, it's not going to make any difference. So they do seem to have read it as, in effect, it's something that requires the disease to be only within the policy area, or to be of itself a but-for cause of the action, and it can't, and that it obviously fails that test, and I accept that. That's how I rationalise that. But what they should have actually done, what they did is they seem to have jumped from the conclusion of local focus to which is an alternative construction, but doesn't exclude my concurrent cause argument, to the as if they were reading the word only. Because you'll remember earlier in the judgment, one thing they said was, we can't read the word only in the relevant policy area. And their conclusion seems to be that they were reading only in the relevant policy area into this clause, not feeling the need to read it in, but construing it as if it has that effect. And so you then have, following from that, the test, well, has this case on its own been causative of the government action? Answer obviously no. But we don't see that passage as inconsistent with the concurrent cause case. As I said, reading the judgment as a whole, it's quite plain what they meant. That's all I wanted to say about QBE3. And if I could then move on, I'm just taking it in order in which the submissions were made, Argenta, and there's not going to be much more to be said about all of these. We go to page 314. You see the definition of notifiable human disease, and it's again illness sustained by any person resulting from infectious human disease, an outbreak of which. And then it's a very similar language, page 317, an occurrence of a notifiable human disease within a radius of 25 miles of the premises. And you've got a similar exclusion to the clause that you saw in QBE policy, QBE2, in Roman 3 on the side. And there isn't much to be added on this policy to what we've discussed before. Unless there's anything specific on this policy which is to put to me, I intended to move on to Amlin 1. And that's at 567, tab 10. That's where the clause is, notifiable disease. Following any notifiable disease within a radius of 25 miles, definition of notifiable disease on 559. Again, it's illness sustained by any person resulting from. The only issue on this one, which is different from the others, is the use of the word following. And you remember Mr. Keeley referred you to places in the policy in which that word had been used, he said interchangeably with resulting from. But if you look on this clause, you'll see there is, in the very same sentence, initially the use of as a result of, and then the word following. And the previous clause on the same page uses the phrase direct result. And this is an insurance policy to be read by ordinary men and women. And when it says consequential loss as a result of something following something else, then we submit that following ought to be given its ordinary meaning, which would not be a word connoting proximate cause, as said Hiscox has accepted. Now that it isn't determinative, but it supports the construction that the court placed on the clause, that this is looking to a qualifying condition. It's a yet further point in support of that conclusion. Not really.
Presumably you accept that there has to be some causal link.
Yes.
It can't just be that one event happens and then another event happens without any connection.
Yes.
So it starts to get a bit sophistical, doesn't it, once we start to argue about different kinds of causation, if there is such a thing. I mean,
yes, but this is, if you were to find any distinction between the policies as to, on the construction point, then the use of the word following would support the construction that they were contemplating, that actually this is never going to be the only proximate cause, or it may well not be the only proximate cause. There are going to be lots of causes. And all you've got to show is that there's some causal connection between the outbreak in the policy area and what happens. And it's consistent with the nature of the risk. And that's all I say.
It might be thought a rather slender basis for a judgment if we were to distinguish between this case and find that if it had used resulting from, the result would have been the opposite.
We have not ever sought to distinguish policies, but this is perhaps an indication. I know one doesn't use words to construe others, and I'm not attempting to do that, but it is an indication of a recognition of the nature of the risk. Because if one looks at the nature of the risk, it's not surprising to find an insurer using a word like following. And because otherwise one would think, well, what on earth, in an insuring clause, what on earth is an insurer doing setting a test which is lower than proximate cause? And that would ordinarily be quite surprising to see something other than proximate cause. And it's why courts usually say, well, there's a selection of words and they will all, in a coverage clause or an exclusion, be construed as proximate cause, even if in an aggregation clause, taking the words arising from, for example, they might not be construed the same way. But here in an insuring clause, they've used the word following, and we just say it just rather shows the recognition of the nature of the risk. And that's relevant to all insurers, because it shows that this was something that they ought all to have realised and was the natural construction of the word. My Lord Hamlin's gone off screen. Yes, I just wanted to check that. That's really all I wanted to say about Amlin 2, because the words, again, it hasn't got the word occurrence in it, but obviously it's got definition of notifiable diseases, any illness sustained, but it's just following an illness sustained. And again, you've just got following someone having symptoms of an illness, or being asymptomatic, sorry, sustained as asymptomatic, manifested as symptomatic, for someone catching the virus. And is it really intended that that should be someone merely catching the virus in the relevant policy area should have to be a but-for cause, or the only cause of what happens? Because Mr. Keeley says that even if it's following, you still have but-for. So but-for what that person being infected, that's what he says this how this clause works, and we say that's unrealistic. Amlin 2 at page 645 in tab 11 at Roman 3 is slightly different format, but substantially to the same effect. It's got the same definition of notifiable disease. If you want the definition of that, it's at 641. It's got consequential loss following, but it's still got the word following. But we have nothing additional to say about Amlin 2. That brings me on to RSA 3, which is the last of the disease clauses. And we go to page 1237. I've taken that before RSA 1 because it is a pure disease clause. And you've got, again, similar language. We've got following again. Make the same submission at the bottom of 1237. We have got occurrence here, occurrence of a notifiable disease within a radius of 25 miles. And it's, again, illness sustained. So it's catching the virus, even though you may not have any symptoms. And I've dealt with that. The only additional point that arises on this policy is exclusion L, which is on page 1292. And two primary points to be made on that. It says it doesn't apply to sections 5 and 6. And Mr. Turner said it therefore doesn't apply to the liability coverage. Now, I may be missing something. I'm the first to admit if I have, but he seems to have overlooked, sorry, I'm just finding the page, that on page 1201, there is another liability section, which is the products liability section, which is 6B, which is not referred to in the title. And so it looks as though this does apply to 6B. It's got a different name. I know it's a subset of, it's 6B rather than 6, but the title specifies employer's liability and public liability and makes no reference to 6B products liability. So that submission we submit is just that it can only apply to this because there's no other liability cover, is simply wrong. And also, one has to bear in mind that it's not just on his submission, it wouldn't just be the word disease that has to go, it's also the word poisoning. Because if we go back to 1238, sorry, 1238, the definition of notifiable disease includes food or drink poisoning. So he has to excise poisoning as well as disease. He accuses us of, in the court, of rewriting the language of exclusion L, but it's hardly a promising start for criticism in circumstances where he himself has to accept that you, on his analysis, you have to put a blue line through poisoning and disease. Of course, we say you don't have to put a blue line through anything, and that's why we say that the alternative approach to construction is correct, because the court's construction of B is correct, and you've seen what the court has said about that, and we adopt that. But we've also got our alternative submission under A, this, which we maintain. And the words pollution and or contamination, as Mr. Turner rightly says, haven't been defined, but it doesn't lie in his mouth to say that the heading is of no relevance in circumstances where the heading is plainly, in this instance, intended to be operative, because it defines the sections of the policy to which the exclusion applies. And in any event, even if it's not part of the policy as such, it informs how one construes pollution and or contamination, because without reference to those words, the clause is meaningless. So those, in brief, are our submissions on exclusion L. This was the only ground on which the court below, when considering alternative grounds for permission to appeal, although in the end granted permission for everything, this was the one ground on which they expressed the view that they believed that there was no real prospect of success. But there we are. RSA have chosen to pursue it. I'm sure, and I mean this genuinely, that there are very good reasons. I don't mean this any other way. There are very good reasons why RSA is pursuing this exclusion, but I suspect they don't have much to do with the merits of the point before the court, but other commercial considerations. RSA 1, if we can move on to that, unless there's any more questions on RSA, any questions on RSA 3, and that is at 1129, and this is the first of what might be called the hybrid policies. The language is taking away the additional element of closure or restrictions. Otherwise, the language is very similar to QBE1. Losses a result of closure or restrictions as a result of a notifiable human disease manifesting itself at premises or within a radius of 25 miles. Obviously here we have, unlike the other policies, a specified effect that it must result in closure or restrictions. I'll return to that when I get on to my appeal. I just want to deal with the our response to insurer's appeal at this stage. And the court construed this as simply meaning that the disease must have manifested itself within the 25-mile radius, and it did. And we say whatever one thinks of, might say about other forms of wording, this one, like QB1, Yes, my lord.
Just for information, is this one notifiable human disease is not in bold? Does that mean that this time it isn't defined anywhere?
No, it isn't defined.
Right.
And Mr. Turner says about this policy, he said the policy is damage based, to which I answer yes, but this extension isn't. It is, but it's premises based in the sense that it must result in closure or restrictions placed on the premises. But within a radius of 25 miles of the premises isn't premises based at all. It's just what this clause is, it requires something to happen to the premises. But that's as far as it goes, and it doesn't help you in any way as to the effect of the radius limit. And that's really all I wanted to say about this aspect of RSA 3. Once one's done one or two of them, one has really the answer one way or another to all of them. If I can now then move on to Hiscox 1 to 4 and start with Hiscox 1 to 3, which all have a common form of clause. And the first one, if I just take it in Hiscox 1 at page 401, and this does not have a vicinity limit. It's a hybrid in the sense it's disease plus something else. Your inability to use the premises due to restrictions imposed, we'll come back to that on our appeal, by a public authority. So it does here obviously require specific public authority action, restrictions imposed during the period of insurance following an occurrence of any human infectious or human contagious disease, an outbreak of which must be notified to the local authority. Now, Mr. Gazeman in Hiscox's written submissions has made submissions about the word occurrence necessarily having a local effect, but he did not develop those submissions already. We've seen what we've said about that in relation to in answer to that. In our case, there just simply isn't any reference to any location where this disease must occur. What it does is obviously requires there to be some causal connection, the use of the word following, admitted by Mr. Gazeman to be weaker causal connection than proximate cause, some causal connection between the occurrence of the disease and the restrictions imposed on the premises. That may sometimes mean that it's local, but it sometimes may mean that it's part of a wider outbreak, which, and the wider outbreak as a whole, causes the restrictions to be imposed. And given that Mr. Gazeman didn't make any further submissions about that form of policy, which is common to 1, 2, and 3, there's nothing more that I need to say about it. I've made my submissions about the counterfactual, and there's, as I have for RSA RSA 1, but I won't, and so I don't need to repeat those submissions. And just moving then to Hiscox 4 at page 497. Sorry, 498 is where the insuring provisions start, and the clause itself is at 499. That's the one that was in the main section, but I perhaps look at this first, because then Mr. Gazeman wanted to take them to another form. But this was the main policy form considered by the court. And it's your inability to use the business premises due to restrictions imposed by public authority following, exactly the same as 1 to 3, except it's got the 1 mile radius. And we say that doesn't involve any additional features. You'll remember while I'm on this clause that Mr. Gazeman emphasised that it's described as a public authority clause. That's because one element of it obviously is public authority action. But that doesn't help you with anything. It doesn't help you with the point we're discussing, and it doesn't help you with the counterfactuals, given that even Mr. Gazeman admits that some difficult to comprehend part of the disease, insofar as it caused the restriction, goes into the counterfactual. So the fact that it's described as a public authority clause doesn't take matters anywhere. Let's go now to the clause that in the policy that he wanted to take you to, and I'll show you why he wanted to take you to it, because there's something in that clause which is missing from this policy. And what it is, it's at tab C, tab 22, page 1559. And what it relates to is non-damage denial of access. And if you remember, Mr. Gazeman took you to that. Right? It's not actually clear what he's trying to do, whether he's saying that this is an aid to construction, which doesn't help him on Hiscox, the version of Hiscox 4 without this clause, or whether he's saying use this clause to help you to construe the clause that's in both forms. But the clause in both forms must mean the same thing with or without this additional extension. Can't mean something different in different policies. But anyway, let's in any event, it's plain, we submit, that these were not intended by Hiscox to be interrelated extensions, because otherwise they would necessarily go together, and they have been omitted from other forms of Hiscox 4. So what we see from this clause is firstly, it refers to an incident within a 1 mile radius, and the short point on the relevance of this is that the court decided that the fact that what had to happen was described as an incident was inapposite to encompass a disease risk. But if it did encompass a disease risk, in sense of a disease incident, it was only contemplating something which was very specific and local, and not a disease outbreak. And there is nothing in that clause or in the judgment which provides any support for Hiscox's case on the Hiscox 4 disease clause, which is addressing a risk of a fundamentally different nature, namely the outbreak of a notifiable disease. and I should have taken you perhaps to the definition of notifiable disease, which is on page 1559. So if you've still got that there with the non-damage denial of access clause, it's any human infectious or contagious disease, an outbreak of which must be notified to the local authority. And in this case, therefore, the word occurrence is not linked to the illness sustained by a person. It's just an occurrence of a disease, an outbreak of which must be notified. And so if you were even if you were against me on occurrence meaning outbreak in other policies, this one, it plainly is referring just to an outbreak. And so the submissions I made in relation to other policies apply here. There's one point I overlooked that I've got to come back to on QBE. Sorry, it's again the delay. Could my lords give me a moment? I've just got to adjust something on my phone because it goes to sleep, and I need to stop that happening so that I don't miss messages coming through. I still find it awkward having a phone when I'm addressing the court, but I'll try and get used to that. Awkward in the sense that I know I shouldn't have a phone, but I do. The ARCH requirement, the ARCH policy, it's C4227. And you'll see here, this is a prevention of access clause. It's linked to an emergency, and ARCH has quite fairly always accepted that the COVID pandemic was an emergency and was one which was likely to endanger life. There is no radius limit. And now I realise there are 2 points that I've omitted. So I'm sorry, but this is I get not getting stickers before I move on from behind me. Means that I sometimes have to come back to things. I wanted to point out that in Hiscox 4, I do apologise for not doing this more consistently. 1561, if we could just go ahead to that in the tab 22, I forgot to make the point that you will see at the foot of 1561, there is a cancellation and abandonment clause, which appears in many of the policies, and certainly both of the forms of Hiscox 4 that we have. And if, and this is perhaps, sorry, I've got the wrong page. It's, sorry, it's at the top of the page. Yes, cancellation and abandonment at the top of page 1561. And you'll see that's an extension, unforeseen incident or event which occurs entirely beyond your control. A promotional event of your business is necessary and unavoidably postponed, abandoned, cancelled, or relocated. And you'll see at subclause 3, one of the exclusions is the postponement, etc., directly or indirectly due to any action taken by any national or international body or agency, directly or indirectly to control, prevent, or suppress any infectious disease. One of Mr. Gazeman's submissions was that no one would have imagined the government taking actions to suppress the disease because this had not happened before. And yet he has an exclusion in there for it. And forensic point perhaps, but if he had wanted to exclude cover for that sort of thing under the disease clause, he could have, his client Hiscox could have done so. Just in passing, while I return to Hiscox, I should have mentioned that Mr. Gazeman did not address any submissions on grounds 4, 6, 7, and 8. That's the meaning of solely and directly, occurrence, interruption, and the application of restriction imposed to Regulation 6. In circumstances where Mr. Gazeman hasn't said anything orally, I likewise will rest on what we've said in our respondent's case to that, with the comfort of knowing that Mr. Gazeman hasn't addressed any oral submissions, but I do understand the pressure of time he was under, as we are all under, and I hope also the courtesy will be taken of not making a point that something wasn't addressed when lack of time was a fact. My other omission, I'm afraid, was back on QBE 2, and it's 8-page 852 in C tab 13. Where it refers to a limit of indemnity any one incident. And the word incident must, we submit, necessarily when it applies to the disease, it can't mean any one case of the disease, because otherwise if there were multiple cases and it responds, there'll be multiple limits of indemnity. Applying that sensibly to the clause, it must be any one outbreak. And that ties in with our construction, our approach, our criticism of the court's reliance on the word incident in the QBE 2 and 3 policies.
I think, Mr. Eggleman, I noticed that point also when we were looking at one of the earlier clauses. It may have been QBE 2.
That was, my lord, that was QBE 2.
Yeah.
And you've got the and so that may be where, well, I've just come back to QBE 2, and that's where it was. And it was, I referred to H, and in my haste to move on, I forgot to deal with I. I'm sorry, it's entirely my fault. But fortunately, I got a message to remind me.
Yes, but under the disease clause on page 852, there's a cap of £100,000.
That's it.
In respect of any one incident.
Yes, and my submission is that can't be any one case of the disease.
Yeah.
It must mean in relation to C, when it's looking at C, it must mean outbreak, and that rather helps you to understand what occurrence must be getting in. If one's trying to read this consistently as a whole, despite the different words to the same effect broadly that the draftsman has been using, it must be any outbreak of a notifiable disease, albeit as defined, within a radius of 25 miles of the premises, which then, as I said, fits in with the court's approach, to construction of other policies, which we say it should have applied to this policy. But in any event, it also fits in with our concurrent clause. And my lords, those were my submissions, and I hope I've covered everything adequately to the court's satisfaction on our response to the appeals. And obviously, if there's anything in due course that arises, no doubt the court will ask a question. I now turn to our appeals, and we start with round one, which is the pre-trigger downturn point. And one has to see this, as we pointed out in our appeal case. One has to take this point into account together with the mandatory instruction point, because subject to a concession that Hiscox has made, which has not been adopted by other insurers, those insurers with this sort of clause which requires the public authority to do something, which are not expressly couched in terms of applying to action or advice, are saying that the restrictions are only relevant restrictions when the government passed legislation, not when the government said, as the Prime Minister did, certain types of premises are to close, schools will close, and it's right to say that because the schools did close, they never passed any legislation in relation to schools. But what they say, even when legislation is passed, is that for those, subject to Hiscox's concession, for those schools, for those businesses that did close in response to what the Prime Minister said, that loss of turnover is then a trend for the purposes of the trends clause, so that when they are forced to close by law, in the sense of being told to close by the government, when the legislation comes in a few days later, and you go to ask yourself what loss have they suffered, well, you say that as at the date they were required to close by legislation, their turnover was zero, and so they have suffered no loss as a result of the restriction, because they'd already closed because the government had told them to do so, albeit in a non-legally binding way. Now, there are two answers to this, but obviously we want both, because the pre-trigger downturn point may have more extensive significance. The two answers are that when the clause itself contemplates something emerging which will trigger an authority response, it is no part of the purpose of a trends clause when doing the mathematical exercise for the post-trigger period to take into account the immediate pre-trigger downturn caused by the emergence of the peril. I'll develop that in a moment. With our additional argument, but if necessary alternative, being that when policies talk about restrictions imposed or whatever imposed, what they are talking about is something which is mandatory, which in a situation of emergency, the ordinary member of the public would expect to, would regard himself as being, or herself as being expected to comply. And I'll deal with that also in a bit more detail. But if I can start first with the pre-trigger downturn point, and which is our first round of appeal. And just let me make one point abundantly clear. We are not suggesting that prior to all of the ingredients of such composite perils being triggered, any losses incurred are recoverable. No part of our case. What our case is that when you're doing the quantification exercise for the business interruption loss caused in the post-trigger period, you do not take into account the fact that the ingredient in the peril, which it was predicted would give rise to a sequence of events, has already started to have an effect on the business before the full house is achieved. Now, there's an element of inconsistency in the court's decision about this, because the court rightly says that, and again, it was a sort of simple example, so it's perhaps why it was used by the parties, because it was a very simple example of people going to church and putting their money in the tin or the collection box. That in relation to, this is at paragraph 389, but I'm sure one of us has seen it. In relation to churchgoers, you don't inquire whether, but for the closure of the churches, the parishioners wouldn't have come anyway because of the pandemic. Because the court rightly said, when you've got a composite peril, you take everything out. You don't start looking at saying, well, of course, the church was closed, so they couldn't come anyway, but is there a concurrent cause of their not going? So there are two reasons why they didn't go. They couldn't go because it was closed, and they wouldn't have wanted to go anyway because of the disease. Rather like the Silverseed case with concurrent causes. And the court said, no, when you've got a composite peril, you take all of the ingredients out. And as you'll have seen, there's one, we make it plain that it's, as I made plain in answers earlier in the course of my submissions, one's dealing with a prevention of access clause, it's access-related losses. So it doesn't include, I'm not suggesting that because the disease comes out, that you're taking disease out, you know, and bringing losses in that have nothing to do with access. Because actually what we're doing here is we're looking at the trends clause. So the one-off, the quarterly donation that someone who doesn't actually go to church very much, only maybe goes once a year at Christmas, if that, but perhaps in the hope of something better in the afterlife, or just to make him or herself feel better, regularly gives a donation to the church. It may be they work on Sundays and they can't get to church. That person ceasing to give money because the restaurant which he owns or at which he works has gone out of business has nothing to do with access. So the loss of that donation isn't in the equation. And that's equivalent, that's the reinforcing the point I was making yesterday. What we're talking about is simply the other question of whether parishioners who can't go to church because it's closed are not to be put into a counterfactual on the basis that they might not have or would not have gone to church anyway, and how on earth would one prove it? That was also the impossibility of proving it. But inconsistently with that, the court said you do take into account the fact that some of them may have stopped coming to church before the lockdown. So that if there was a 10% fall in collection income in the week before the church was closed, you take that 10% as your going forward starting point. So in other words, the church could only recover the difference between 0 and 90%. And we say that is actually inconsistent, because if you're excluding the disease insofar as it affects access, you should be excluding it for all purposes. And of course, yes, well, yes.
And this is really the same argument, isn't it, as you were making yesterday in relation to the but-for language and the trends clause, that to give it, you submit a commercial reading, you can't construe but for the damage as confined to just the damage to the hotel, let's say in the New Orleans example. It must include the wider corollaries of that, the other hurricane damage. And the only additional point is that it doesn't matter if the other buildings got hit first or afterwards. It's still part of the wider incident, if you like.
Yes, absolutely.
You don't take into account in calculating the loss.
Yes. And it would be like in the hurricane case, if the hotel said, no, this hurricane could hit, we don't want to be doing things at the last minute. We're going to, for the safety of our guests, we're going to close the hotel a week, or it wouldn't be a week, but 2 days before the hurricane hits, and we're going to board up the windows. And then, of course, the hurricane devastates the hotel. The boarding up is just like a piece of sticky tape. But do you then say, oh, well, you were closed for 2 days, your starting point when the damage occurred was 0? And we submit it's unreal. Now, of course, if there's some extraneous reason, nothing to do with the insured contingency, and the income had, unfortunately for the business, gone down to 0 a couple of days before some other incident, then it's going to be a question of fact as to whether that 0 would have recovered. But that would be an entirely extraneous question, but it's something entirely different, where you have a peril which the policy itself contemplates. And let's look at this was the Orient Express case, I'm afraid. It was a hotel in the Gulf of Mexico, or near the Gulf of Mexico. And hurricanes, I'm afraid, don't hardly happen. They frequently happen in the Gulf of Mexico, and it's a matter of pot luck where they're going to hit. And people know that and they prepare for them. And here there is a disease risk. The policies actually contemplate, these hybrid policies actually contemplate a sequence of events. They contemplate that the disease or the emergency will arise and develop. Of course, in Archie's case, when it refers to an emergency, it could be a sudden emergency, but it could be a developing emergency. But in the disease clauses, it is more self-evidently going to be a developing picture, as recognised by the fact that Mr. Gazeman's A plus B plus C plus D is almost proof of this point, that you have a sequence of things that the policy contemplates must happen, and they necessarily contemplate that it's the disease that starts first. And for the court to take the disease out afterwards, but then to give effect to it before, we say is inconsistent. But in any event, it is it's not consistent, as I submitted, with the history and the commercial purpose trends clauses. And it is interesting to note that Hiscox has made that concession. It's very proper of them to have done so, and I applaud them for doing so, although they've not been, that's in the context of their still resisting any cover under their policies. But they have at least acknowledged that. But what they haven't done is to explain the basis on which they are doing it. Mr. Gazeman was dealt with this at the consequential hearing. You've probably seen this in our written case, but did not give a legal rationalisation for it. So at the moment, it stands as a purely ex gratia concession as far as insurers are concerned. And it's not right that it should rest on that basis, in particular because the other insurers haven't adopted it. And everybody needs to know, the loss adjusters need to know, whether that concession is an ex gratia one or whether it reflects the legal situation. And of course, it may not be confined to the difference between the period when the government, for example, told someone to close and when they actually passed the legislation requiring them to close, because social distancing, the social distancing statement, we say that's enough as well, but that of course also came in, was started on the 16th of March, and there may have been other downturn effects on the business surrounding that period, which again, the parties will need to know whether or not those are to be taken into account in making this quantification exercise under the trends clause. And that's where it does arise. Are you adjusting the income figure for the impact that this emerging peril had started to have on the business before it had the full house effects?
Mr. Edelman, it strikes me there may be an aspect of a case such as the present, which is materially different from the hurricane example. If the trends clauses are to be interpreted as meaning that businesses can only recover if they ignore government advice issued in the interest of public safety to cover the period before legislation can be brought into force, then the effect of that, giving that reading to the contract, is to encourage companies to behave in a socially irresponsible manner, which would damage their commercial reputations and be contrary to the public interest.
Yes, I mean, that's quite right. But unfortunately, the insurer's answer to that would be, well, we're not insuring their public reputation. And that's what their answer would be. We are insuring. Yes.
Yeah, but one has to interpret the contract in a way which reflects what one could reasonably take to be the party's intention.
Yes. Well, that's our primary submission on ground two, and I perhaps it might help if I that is essentially the point we make. I can't remember who gave me our case, but certainly I would draw an analogy with it may be an extreme analogy with the Second World War, because the emergency we're facing at the moment, and obviously can't compare to what the population went through in that war, but there are few national emergencies that occur in anyone's lifetime, and in that period, people would expect themselves and be expected to comply with things that the government told them to do for the purposes of public safety, without regard to whether the government had passed legislation and whether they were legally bound to do so. It was a matter of social responsibility. And there was, and I was going to give him the credit of mentioning it, but there was, and I don't usually refer to newspaper articles in this, but there was a an article by Times journalist Matthew Syed, in which he made the point that the difference between free democratic societies and those that are not is that free and democratic societies work on the basis that the population generally, obviously there will be exceptions, the population generally is willing to act in a socially responsible way. It's why, by and large, we don't have an armed police force. Obviously, in exceptional circumstances, the police have to be armed, and in certain circumstances are. But it's because underpinning the way in which free democratic societies operate is that they can rely on the population as the price of your freedom, that you will act in a socially responsible way when you need to.
But perhaps if one reduces it to a more mundane level, if, say, an infestation of vermin were discovered in the kitchen of a takeaway on a Saturday evening, and the statutory order closing the premises couldn't be issued until the Monday, it would be extraordinary, it seems to me, if the contract effectively required the business to carry on trading on the Sunday in order to be able to recover compensation.
And it would be all the more extraordinary, we agree with that one, or we made similar points in our case, it would be more extraordinary if an order was made on the Monday, it stayed open despite the rats until the Monday. The order was made on the Monday, and he then closed, and then it transpired that the person who issued the order didn't have the authority to do so. And it was of no legal effect. And the error maybe was never corrected or not corrected until the Friday. Or if the local authority representative said on the Saturday, as soon as the office is open again and my boss is back, but he's not back till Wednesday, you're going to get an order closing you. And the restaurateur then closed. But of course, in our case, the government didn't threaten legislation. The statements don't say, if you don't do this, we're going to make you do it. They relied on public compliance. And we get to the position, the rather ridiculous position, in relation to schools, if you're going to strictly apply insurer's case, that for some reason, the government never bothered passing legislation. And so you have the case which is now relied on by insurers, where someone applied for judicial review in respect of the government action closing schools, and the court rightly said, well, actually, there's nothing to judicially review here because they never passed a law. And insurers say, well, that shows you that that it wasn't legally binding. Well, yes, but the schools closed because there was an emergency, and they knew, as a matter of public safety, that as a school they just had to close. But insurers are saying, as a matter of legal entitlement, putting aside ex gratia concessions, they're saying as a matter of legal entitlement, they're entitled to take they can take into account this downturn. So there are two answers, but both may be right. It's not an either or. Both may be right. It's one of the
Well, they have slightly different consequences anyway, don't they? Because in order to claim, as opposed to not have your loss discounted, but to claim loss for a certain few days at least, you have to be right on the imposed point.
Yes, the imposed does help with days of cover. That's quite right. I mean, sometimes with some of these policies, the limits are so low that it may make one or the other may make a difference. But it is important actually to backdate the cover. So, my lord, is that correct to me? is
I
right.
mean, the main point made, or what I take to be the main point made against you on the imposed, is that it introduces difficult questions of degree. And if something's expressed, let's say we could accept that if the Prime Minister says you must do this, well, that's an instruction. But what about if you're advised to do this? One has to then make quite fine judgments sometimes, because obviously there is some advice which is genuinely intended to be guidance, which isn't compulsory.
Yes. And we have tried to formulate a test for that, which is simply, is it mandatory? When you're not in legal effect, but is what is being said mandatory? Now, this is what you are expected to do.
Well, given that you've lost on that point, are you inviting this court to make what's basically a judgment of fact and degree, or how are you inviting us to deal with the point if we think you're right in principle?
Well, my lord, we have identified the various statements that the Prime Minister made, the various announcements that were made, and the ones we have relied on are the ones that we say were all expressed in mandatory terms. Even if said, we are asking people to do this now. That wasn't just saying, you know, if you want, we're asking you to do it if you'd like to, if not, don't. This is what we want you to do. The fact that something is expressed politely doesn't mean that it wasn't intended to be mandatory, that this is what was being expected of the population. And so,
what about things expressed in terms of, well, don't do it unless you have to?
Well, if it's don't go to work unless it's necessary to do so, then that is doing it exactly. It's mandatory. Unless you have to go to work, you shouldn't be going to work. And
whose judgment is that as to whether it's necessary or not?
Well, that would obviously be on the individual facts, but it perhaps doesn't apply so much. But when there's restrictions imposed on premises, closure or restrictions imposed, save to the extent that you can say that people weren't allowed to go to work for that purpose. But it would be relevant, for example, to office staff, professional staff, us as well, because if the government said don't go to work unless you have to, and then solicitors and barristers work from home, and it's maybe in some cases not as productive, and there may be some additional expenditure which is incurred because all the IT systems have to be upgraded. There may be some cancellation of cases and so on. That is, people have complied with it, and saying that, well, it's that will be for the loss system. So, well, actually, you stayed at home when in fact you were entitled to go to work. That would be on the adjustment process, and there would be a dispute about it. And if the parties couldn't agree, then they would go to arbitration or to court. But whether it was necessary for somebody to go to work is an objective test which can readily be applied. Just ask, what do you do? Why couldn't you have done it at home? Yes.
I think it's the same issue arises even when it does become legally binding. Because, for example, Regulation 6 says you must stay at home unless you've got a reasonable excuse.
Yes.
And ultimately, that will come down to a fact-intensive analysis of excuses unless they're listed
Yes.
as it were, deemed reasonable excuses.
Yes. Quite. I mean, they are. That's actually right. Often and it's not unfamiliar in all areas of law to have matters which are elements of judgment, and even one case that on aggregation clauses, often the language is deliberately left vague and general so that it's adaptable to all circumstances. In this case, I can't remember what the constitution of the panel was, but I'm sure one or more members of this panel dealt with it. The AIG and Woodman case on the fact that the solicitor's minimum terms use the word related. Matters or transactions had to be related. Now, related is a flexible term. The courts below had tried to impose some constraints on it because they thought it was too vague and general. And the Supreme Court, this court said, no, it's there because judgment needs to be exercised on the facts of each case. That's also an insurance policy. And that can be an issue on which many millions can turn because it depends whether the primary layer insurer pays repeated £3 million limits, or whether the excess layer pays, let's say, a 7 million limit, and whether the insured, the policyholder, gets a 10 million indemnity or multiple 3 million indemnity. And it's something that would have to be assessed on the facts of each case. So that's no impediment. It's something that insurance is well used to. So it's specifically an insurance so that's an insurance provision, which is, as the court said, as said in Scott and Copenhagen Re, often these clauses are deliberately kept general so that they are adaptable to the facts. So that it's not an impediment at all. So that's what we would invite the court to do. This is really jumping ahead to ground two. I'll go through the language of the clauses specifically, but what we would like the court to do on ground two is simply to say that all of those statements on which we've relied, they are all mandatory instructions from the government, and they all qualify under the various clauses, and so should be the indemnity should start from that date. As I said, we've also got the pre-trigger downturn point, which it doesn't really. I've made the inconsistency point, and it doesn't bear much repetition. I think we've made it in our case, and the point is as it is. Now, I would only perhaps give, again, I gave the hurricane example, the cockermouth example again. It might help illustrate the point, because the same would apply to floodwaters. If in the cockermouth example, the floodwaters rose slowly rather than suddenly, and they rose, as can happen in these flood cases, if they're more remote from an immediate source of flooding, and say that the waters rose for a day or two, and a shop on the highest ground wasn't affected, and because it was the only shop open, it did a roaring trade. Because maybe it was to one side of the property there was flooding, but to the other side people could get to it. And then the flood waters rose and it was inundated with water. Is its loss of turnover to be assessed by reference to those 1 or 2 days of roaring trade? Or can the loss adjuster say, no, come off it? That's the effect of the very flood which has caused damage, and that's not the true picture of your business. The true picture of your business is what it was before this flood water ever appeared. That answer by the loss adjuster would, we say, be absolutely the correct answer, and it would be doing exactly what trends clauses are supposed to do. And it shuts out, therefore, the windfall as well. Someone might say, well, all these other fools, they all closed, but the government hadn't passed legislation, or the government hadn't made us close, so I stayed open. And this is my trade up until the government passed legislation making me close. And so thank you, I'll have my claim adjusted for being the only irresponsible bar owner who had people pouring out of his bar desperate for a drink before lockdown. So it would be, it gets rid of those cases as well as providing a more level playing field for those who did shut. Now the mandatory instructions, sorry, I'm just getting a note, I might just look at that. Can I just refer to a passage in Amlin's case at B tab 15, page 604. And it's this is moving on to the mandatory instructions point. And it's a reference to the House Rules, House of Commons Joint Committee on Human Rights briefing paper. He said, and included the following passage: regulations put the new measures announced by the Prime Ministers on a statutory footing, making them legally enforceable from 1 p.m. on Thursday 26th. It's important to note that prior to this, there was no legal basis for the announced restrictions on movement and gatherings. We have more general concerns about recent disconnecting the laws that are enforced and therefore binding and announcements, directions, or instructions from the government which have no legal force, but which are communicated in such a way as to appear binding. Now, this is cited against us, but we say it supports us, because this confirms that these were statements which were made to appear binding. And that's not to suggest that the Prime Minister was misleading people into believing there was legal force when there wasn't. They were expressed in a way that were directive, were mandatory. We don't take issue with Lord Sumption's analysis, which is heavily relied on by insurers, who did as one would expect, very learned exposition on why what the government has said wasn't legally binding. Right, yes, we accept all that, but it's nothing to the point. Absolutely nothing to the point. That is not how we would want our society to operate. It's not merely, we don't live freely and happily together simply by doing the minimum necessary to obey the law. And if we all did that, it would not be a pleasant place to live. We do what is necessary in order to function together freely, but also for social protection, to protect each other. And this is an example of that. So the one concession that we have on the legal enforceability issue was in relation to RSA 4, and in the judgment of the court found against us on this, the court at paragraph 303, which is on page 120, they say, in our judgment, there will only have been an enforced closure if all or part of the premises is closed under legal compulsion. We agree with RSA that this would extend to closure which either is or is legally capable of being enforced. By legally capable of being enforced, we include a case of where a governmental authority or agency or local authority directs that particular premises should be closed and states that if they are not closed, then a compulsory order for their closure will be obtained. But we consider this type of situation to have to be a clear direction by authority which has the power to close, that they should be shut, failing which a compulsory order will be obtained. So they say that it's only enough if there's an explicit threat of legal enforcement, but they at least say that there doesn't have to be legal enforcement. But we say, why is it necessary to go so far? What if the threat is implicit? In the sense that a reasonable person would understand that regardless of whether or not what he's being asked to do has legal force, if there is disregard of what they have been asked to do, something will have to be done about it. And that something will necessarily have to be legal force. And it's not difficult to work out that if after the Prime Minister's statement on the 16th of March, or his subsequent statements, people had generally ignored what he had asked them to do, there were two alternatives. Either the government shrugs its shoulders and say, oh, well, we tried, let's have everybody die of COVID. Or the government would have to do something to force people to do it. But the court seems to be saying, unless the government actually threatened people, unless you do this, we're going to pass a law that's going to make it a criminal offence for you to do it. It's not enough. But if the reasonable person would understand that if people don't obey this sort of thing, it's so serious that the government is going to have to do something about it legally, then that should satisfy as an implicit threat alone. So we say, even without this threat point, we should succeed in a time of great national emergency, and the government tells people this is what you must do for everybody's benefit. And to protecting the NHS, which was part of the slogan, it was so that beds would be available, so that people who were ill, which could have been any of us, would be able to be treated if necessary. It was for the benefit of the public as a whole. And that should be enough. But if there is an implicit threat, there's a necessary, it's an obvious one.
But the way it was put, Ms. Redwan, by the government in its written guidance to businesses, I'm looking, for example, at the guidance issued on the 23rd of March, which is it's C1849. And you'll see under compliance.
Yes.
Under compliance, it says everyone is instructed to comply with the rules issued by the government. Now, that's a sort of way of putting it that occasioned the criticism from Lord Sumption and others. But it then go on to say that as of 2 o'clock on the 21st, closures on the original list from the 20th of March are now enforceable by law. So the Prime Minister had announced the original list of businesses on the 20th of March that had to close, cafes and restaurants and the like. So they're saying that's now enforceable. The government will extend the law to include the new list of premises for closure. That was the list that the Prime Minister had announced on the 23rd, which included a variety of premises like gyms and so on that hadn't been included previously. So they're not saying do it or else we'll follow it up with law. They're saying we make the announcement, we expect you to comply.
Yes.
The law follows
Yes.
a day later or however many days later it may take, presumably because of the lag between the adoption of a policy on the advice that they're being given and getting that drafted in a way which can be given effect as a statutory instrument.
Well, yes, it's just like the local authority officer who comes down and says, I'm going to close you, and has to go back to the office and go through, quite rightly, various procedures before the draconian step of actually issuing a closure order can be issued.
Yeah.
But it shouldn't, it's not, we submit, not necessary for something as extreme as extreme as that to be promulgated. But that the fact that the court below was not prepared to accede even to these announcements satisfying the clauses, we say is demonstrably wrong. But let's go to the Prime Minister's announcement on 16th of March. And it starts at 1782 and tab 29. And this was the first really critical of a series of announcements that were made. And he explains the purpose of what he's doing, which brings home to everyone that this really is a national emergency. It's not in the trial below, this sort of thing was likened by Mr. Keeley to the government telling us all that we must eat 5 pieces of fruit a day. It's just advice, and we can take it or leave it. But that, no doubt, Mr. Keeley's usual frivolity is rather understating the importance of this. And it said, last week we asked everyone to stay at home who had one of 2 key symptoms. Today we need, this is on the top of 1783. Today we need to go further, he explains why. Without drastic action, cases could double every 5 or 6 days. So what he's explaining is that drastic action is necessary. And he then goes on to spell out what the drastic action is. And what insurers rely on is the fact that he was only asking people to do something. So first we need to ask you to insure. And
this advice wasn't directed towards businesses. That came, I think, for the first time on the 20th.
That's right. But this obviously began to affect businesses, and we'll look at the clauses, because it starts to affect people's movement. It does. It does affect businesses because he says, second, now is the time for everyone to stop non-essential contact with others, stop all unnecessary travel. We need people to start working from home where they possibly can. And you should avoid pubs, clubs, theatres and other social venues. So there are things that do start affecting businesses, and this is in mandatory language. And it's explained in circumstances where, yes, there may be in other cases dispute at the margins, but there can be no doubt, whatever people may have thought about the rights and wrongs of it in terms of whether it was necessary or not, although people may think it was now proved to be necessary, to have been necessary, but there's no doubt that there's not much room to maneuver as to whether this was in something that was intended to be mandatory. It may have been polite. Of course it was polite, because if you're rude to people, they're not going to do what you want them to do. It was expressed as politely as, sorry.
But are you suggesting, for example, that if a business is a pub and that this constitutes a restriction imposed on its ability to open?
This would qualify if there was a prevention of access clause. We would say that people were being told not to go there.
But does that amount, and do you contend that that amounts, we could look at the wording, but to inability to use the premises because of a government restriction, if you're the pub owner?
Yes. Yes. I mean, how could you use it if people can't go, aren't supposed to go there?
Well, they can. They're just, I mean, this, I think it'd be hard to read this as saying nobody must go to a pub.
Well, it does say you should avoid pubs, clubs, theatres, and other such social venues. It's difficult to imagine how that could be clearer. Now,
well,
whether it amounts...
The announcement on the 20th is clearer. It says we're collectively telling pubs to close tonight,
yes,
and not to open tomorrow.
Yes. Now, it may depend on the language of the clause. If the clause requires closure, then obviously that didn't happen until the 20th. Obviously. And then all you have is the fact that there will have been a downturn prior to the 20th because of what the government was saying. And then you then have my pre-trigger downturn point that if you have a closure which is caused by disease or emergency in the clause, that you don't take into account the downturn in revenue that occurred in the lead up to the 20th.
But that goes much wider, because I take it on your case, you ignore all the downturn that was already happening because people were frightened of going out to pubs because they knew about the virus, regardless of what the Prime Minister said.
Yes. But that's not difficult, because what actually, it does vary from policy to policy, but what many policies do on the trend, on the adjustment machinery, is if, let's say, the pub was closed from March till June and had no revenue, you would then go back under most clauses, not all of them, but under many of them, you go back to March to June the previous year and say, well, that was your revenue last year. I'm now going to treat that as your starting notional loss of turnover. Is there any reason for us to adjust that figure for trends and circumstances?
Yeah, no, I don't have a difficulty with how you go about that.
Yeah, and so that's why you then say, well, oh yes, but well, now I see that in the 2 weeks before the 20th, your downturn, or the 3 weeks before the 20th, your revenue was much lower. And so, well, yeah, because of COVID. So that downturn is not relevant. My figures, my March to June 2019 figures, are the figures you should be taking. Because if you take the first half of March 2020, those are artificially depressed by the very COVID crisis, which is an element of the insured peril. So,
I think we moved away, because my question was really directed towards your restrictions imposed. And
yes, I'm sorry.
I was just having some difficulty with, if we were to, suppose we were in your favour generally on the point, if we were to rule that the PM statement was mandatory, that might be a bit too broad without looking at particular language or particular parts of it and looking at particular effects or how they might be reasonably understood by particular business sectors.
Well, my lords need only say that those businesses which were referred to for those businesses to which reference was made in that statement, and then the parties will be able to work it out. What we hope is that if my lords are in my favour in any of these respects, then once we get your judgment in principle, we can then formulate some declarations. But if you would say that if a business was told to close in the statement of March 20th, that would be a restriction imposed or an enforced closure for the purposes of the clause. And then the parties can apply that because the statement says what it says. And the court doesn't need then itself to work out who was and who wasn't mentioned. The parties will be able to do that for you. And it's really the point of principle that, and this test case was all about points of principle, leaving the facts of individual cases to be dealt with by adjustments and, if necessary, dispute resolution process, was to remove roadblocks to settlement. And one of the roadblocks was this question as to whether closure before legislation is firstly outside policy cover, and secondly is something that a loss adjuster can use in adjusting the claim, in the sense that you've gone down to zero before the policy was triggered. So, and those are the two critical points. And it's really resolving those points of principle that's necessary. It might then be helpful if I started. I think I've probably said enough that I want to generally, and it may just be that we now have to go through some of the individual clauses just to see if there are any quirks or variants on those. And we should perhaps start with Arch, just simply, I'm doing it alphabetically actually on this one. And that's at C. But there are some other, there's a ground 3 appeal as well as to what's meant by prevention of access. So perhaps I should introduce that topic, which is ground 3, and then go to some particular clauses and deal with it. And I was going to just show you the leading prevention of access wording, just so I can introduce this ground. It may be a useful way of spending the remaining time today. And in Arch, the disease clause at page 227, this is round 3 of our appeal, prevention of access due to actions or advice of government or authority. You'll see that no issue arises on the first point because it's actions or advice, which actually we say supports our case because it rather demonstrates here an insurer contemplating that the government may act through advice. So we say this is strong contextual support. And I'm not using one word to construe other policies, but it's just showing what is in the contemplation of an insurer, that the government does act, that authorities do act through advice. But the real focus of this is on prevention of access. And the critical point is whether there is prevention of access only, as the court found, when all access for all purposes is prevented, or whether there is prevention of access if access for a particular purpose or by a particular class of persons is prevented, even if access for other purposes by other classes of persons is permitted. So the example that we gave below, and I give again, is there a prevention of access to a road to those who want to use the road as a through route if it's closed save for use by residents and those visiting them. Assume that there's a policeman there controlling who goes down the road to ensure that only those falling within the permitted class are allowed past the barrier. Is there a prevention of access to the road? And let's assume that some way far up the road, which really needs to be driven to, is a shop which relies on through trade, people driving through to stop at it. Insurers say no, because, and the court says no, because residents and their visitors can still use it. We would say on the ordinary use of language and the ordinary understanding of the term, there most certainly is a prevention of access to those other than residents or those visiting them. There is a prevention of access because certain classes of person are prevented from getting there. Some classes are not, but some are. And it wouldn't be a misuse of language to say there is a prevention of access to the road, because one class of users cannot use it. This has very real significance for shops and restaurants, for example, because insurers say there is no prevention of access if customers are not allowed to go to a shop and the shop owner is not allowed to let them in to buy in store, but the shop staff can still go into the shop to process mail orders. So they say, well, the fact that the staff can go in and process mail orders shows that there is no prevention of access. Similarly, insurers say no prevention of access if customers are not allowed to enter a restaurant to dine in the restaurant, and the owner is not allowed to let them in to dine in the restaurant, but the kitchen staff can come in to cook takeaway meals, and maybe people can come and collect takeaway meals. Is there a prevention of access? Insurers say no, because the staff can come in and people can come in and collect a takeaway. We say there is, because there is a prevention of access for a particular class of persons for a particular purpose. People who want to dine in the restaurant are not allowed to go in. And that's what we mean by partial prevention. Carried to its extreme, insurer's case would be that if a road leading to a restaurant was closed to everyone, preventing access by all customers for all purposes, but at the back of the property there was a way in that enabled kitchen staff to get to the kitchen to cook takeaway meals, carry them to a nearby open road for someone to collect from them so that they could be delivered, there would be no prevention of access satisfying the clause. That, as we understand it, is what insurer's case is. We say, and I'll come to the individual wordings, but you've obviously already seen arches and yes, my Lord Hamlin.
So if you're right on ground one, do any of the points on grounds 2 and 3 matter?
Oh yes, this one is a complete answer, because they're saying that if there's if for example a restaurant is ordered to close for dine-in, but had an existing takeaway, they say if it didn't have a takeaway restaurant, it's fine, because then it I'm not, maybe, no, not on prevention of access, it's inability to use. On prevention of access, they're saying once it's told to close as a restaurant, because it can still open as a takeaway and the staff can still go to it to cook meals, there is no prevention of access. So there's no cover. The policy isn't triggered at all.
At all, I see. Yeah.
And so that is fundamental. I think my takeaway meal example may have to well, I was going to say that simply means that there's no, I think I did finish that. And I've seen it's 4 o'clock. So perhaps if I pause there and resume tomorrow, I'm well up to where I wanted to be.
Yes. Well, if any of us has a takeaway meal, we may pay more attention than we normally would as to how it's all organised.
Well, my lord may reflect on the fact that having the takeaway meal is preventing and insured from getting any indemnity under the policy. If it has a prevention of access clause.
Well, thank you very much, Mr. Edelman. We'll adjourn now and resume at 10:30 tomorrow morning.